Every day, you and I are generating and interacting with, well, an incredible amount of information. Your browsing history, your online purchases, even, where you walked yesterday. It's all data. But that brings up a really big question. Who's actually in control of it? Who decides what happens to our digital footprints? Today, we're taking a deep dive into exactly the absolutely fascinating, complex, and surprisingly long journey of how data protection law has evolved in Europe. It's a story of humanity constantly playing catch-up, trying to put legal guardrails around technologies that just race ahead, always balancing individual rights with relentless technological progress, and of course the demands of international trade.
Yeah, and for this deep dive, we've pulled from a really rich collection. Core legal documents, treaties, Council of Europe guidelines, historical accounts. Together, they map out this progression from the very first sort of whispers of concern about personal data all the way to the robust modern regulations that impact us daily.
And our mission for you, the listener, is clear. We want to extract the core reasons behind these laws, trace their deep human rights origins, and understand the critical turning points, the moments that really shaped how your personal information is protected today. So let's cast our minds back. The early 1970s. What was happening right then that suddenly elevated data protection from maybe a niche concern to something that really caught the world's attention?
You saw a perfect storm of powerful factors coming together. First, computers, particularly those large mainframe computers, were rapidly becoming widespread. This meant public administrators and big companies could suddenly build these extensive databases of personal information, processing and storing huge volumes automatically in a way that just wasn't possible before.
Right, the scale change.
Exactly. And second, the European Economic Community, the EEC, the precursor to today's European Union, was fundamentally designed to break down barriers to trade, to create a single market across Europe. This naturally led to more international data sharing and processing. Data wasn't just staying within national borders anymore. It was, flowing.
Ah, okay.
The dual impact of this was immense. Incredible boost to efficiency and productivity, yes, but also this growing unease about individual privacy, especially as that personal data started crossing borders with such ease.
That's a great point. I mean, privacy laws had existed for a while, right? People had concerns about privacy before computers.
Sure.
So what specifically about automated storage and cross-border movement made those older laws, not enough for this new digital landscape?
That's really the crux of it. Traditional privacy laws just weren't designed for the scale and speed of automated data processing, nor for the ease of cross-border movement. It's like trying to apply, horse and buggy rules to a jet engine.
Right.
This new reality demanded new standards. Standards that could simultaneously give individuals genuine control over their information while also supporting the essential need for free trade within the EEC. It was a classic balancing act from the very beginning, and it's a tension that technology, continually amplifies.
Okay, here's where it gets really interesting for anyone trying to understand the European approach specifically. Before we even get to specific laws, we have to grasp the bedrock. Data protection in Europe is fundamentally rooted in human rights. Can you elaborate on that? Why is that so critical?
Absolutely. In the European Union, protecting the right to privacy and related freedoms isn't just, a good idea. It's considered a basic human right. This conviction forms the crucial basis of all EU data protection laws. It makes a very different philosophical starting point than in some other parts of the world.
Okay, so let's look at the foundational documents then. First, the Universal Declaration of Human Rights, UDHR, from 1948. What did it establish regarding privacy?
The UDHR, it's a monumental document. It acknowledges universal values, dignity, equal rights as the very foundation of freedom, justice, and peace worldwide. Now, the UDHR establishes this fundamental right to privacy in Article 12. It states that no one should face arbitrary interference with their privacy, family, home, or correspondence.
Okay.
And everyone has the right to legal protection against such interference. Pretty clear.
Seems straightforward.
But it also includes Article 19 on freedom of expression, the right to hold opinions, seek information, share ideas.
Ah, okay, so potential tension there.
Exactly. And this is a vital point because while Article 12 emphasizes privacy and Article 19 freedom of expression, which might seem to conflict, Article 29.2 directly addresses this. It acknowledges that individual rights are not absolute. Limitations might be necessary to balance individual freedoms with the rights and welfare of others in a democratic society.
Right.
This introduces a persistent challenge, a theme we'll see again and again in data protection law, finding that precise point of equilibrium.
Okay. Following the Universal Declaration, we have the European Convention on Human Rights, or ECHR, from 1950. What makes this treaty so significant for our discussion today?
The ECHR is an international treaty developed by the Council of Europe to protect human rights and fundamental freedoms, building directly on the UDHR. It entered into force in September 1953, and uniquely, it legally binds its member states to provide these rights to everyone under their jurisdiction. That's a big step.
Binding. Okay.
And what makes it so powerful is its scope. It protects things like the right to life,
Mhm.
prohibition of torture, freedom of expression, and critically for us, respect for private and family life. But its real significance, perhaps, comes from its enforcement system. The European Court of Human Rights, the ECTHR, in Strasbourg.
Ah, the court.
Yes, its rulings are legally binding on states, and they can force changes in national legislation or practice. The court system itself was later restructured, made into a single, full-time ECTHR in 1998, emphasizing its importance.
And how do privacy and expression within the ECHR itself echo what we just heard from the Universal Declaration? Are they similarly nuanced, that balancing act again?
They absolutely are.
Right.
Article 8 of the ECHR is almost identical to Article 12 of the UDHR.
Yeah.
It clearly states, everyone has the right to respect for his private and family life, his home, and his correspondence.
Okay, same foundation.
But here's where that balancing act comes right back in. It then outlines the qualifiers. There shall be no interference by a public authority with the exercise of this right, except such as is in accordance with the law and, if necessary, in a democratic society. And then it lists reasons like national security, public safety, economic well-being, crime prevention, health, morals, or protecting others' rights.
Right, a whole list of potential justifications.
Exactly. It makes it crystal clear that privacy is not an absolute right. Necessity and proportionality might justify breaching it. And similarly, Article 10 of the ECHR protects freedom of expression, sharing information and ideas across borders. And this right is also qualified. It can be restricted to protect things like national security, public safety, and, importantly, the rights of others, including individual privacy.
That cuts both ways.
It really does. Both the Universal Declaration and the ECHR fundamentally recognize this need for a dynamic balance between rights and justifiable interference. It's just woven throughout the entire fabric of data protection law.
So with human rights as this, well, profound backdrop, how did countries start turning these high-level principles into concrete national laws? What did that look like on the ground?
Well, from the late 1960s into the 1980s, it was primarily European countries taking the lead. We saw nations like Austria, Denmark, France, the Federal Republic of Germany, Luxembourg, Norway, Sweden. They started enacting legislation. These early national laws often focused on specific sectors, maybe government data, but they varied quite widely in their approach. It created a bit of a patchwork of protections.
Disaster. Okay.
And notably, in Spain, Portugal, and Austria, data protection even became a fundamental right enshrined directly in their constitutions. That's a strong statement.
That is significant, but a patchwork implies inconsistency, right? That must have caused issues. What was the Council of Europe's crucial next step to try and, well, bridge these differences?
You're spot on. The inconsistencies quickly became problematic, especially with data starting to flow more freely. The Council of Europe realized national laws weren't fully protecting privacy rights under ECHR Article 8 amid this advancing technology and the rise of transporter data flows. So they created principles through recommendations and resolutions in the late 60s and early 70s, resolutions 73.22 and 74.29, for instance.
Okay.
These set initial guidelines for protecting personal data in automated data banks covering both private and public sectors. The aim was really to prompt the development of national laws based on these common resolutions. Differing laws among member states just created an urgent need for stronger international standards.
What other significant initiatives emerged in the early 1980s that tried to tackle this growing international challenge? Sounds like momentum was building.
Yeah, two really pivotal developments came about around then. First, the Organization for Economic Cooperation and Development, the OECD, published its guidelines on the protection of privacy and transborder flows of personal data in 1980.
The OECD guidelines, right.
And then the Council of Europe released its Convention for the Protection of Individuals with regards to automatic processing of personal data, known much more simply as Convention 108 in 1981.
Okay, let's unpack the OECD guidelines first. What was their goal and what made them unique, especially coming from the OECD, which is focused on economics?
Right, the OECD's main goal is promoting economic growth, employment, living standards. And their membership extends globally, beyond just Europe, which gave these guidelines a very wide impact, potentially. Published in September 1980, these guidelines set basic rules for data flows and privacy protection, trying to encourage, similar data protection laws across countries.
They're not binding.
Exactly.
Right.
What's really important to remember is that they were not legally binding. They were designed to be flexible, intended as a foundation for new laws or maybe additions to existing legislation. Their aim was that classic balancing act again, safeguarding privacy and individual rights while not hindering trade, actively promoting smooth data movement across borders.
Makes sense for the OECD.
And notably, they treated both public and private sectors equally and applied to all types of technology, electronic or not. Quite forward-looking in that sense.
And what were some of the fundamental ideas, the principles these OECD guidelines brought forward? Did they really start to shape how we think about data protection?
Oh, absolutely. These principles really became the building blocks for pretty much everything that followed. First, there was the collection limitation principle.
Yeah.
Basically, personal information should only be collected fairly, lawfully, and ideally with consent.
Okay.
Then, the data quality principle, emphasizing that data must be relevant, complete, accurate, and kept up to date. Makes sense.
Yeah.
The purpose limitation principle meant that when you collect data, you have to specify why you're collecting it. And any future use has to be compatible with that original purpose. You can't just collect it for one thing and use it for anything else later.
Right. Purpose specification.
We also saw the use limitation principle, meaning data disclosure should be consistent with its initial purpose unless there's consent or, lawful authority. The security safeguards principle required reasonable protections against loss or unauthorized access. Pretty standard now, but important then.
Mm-hmm.
The openness principle promoted transparency about data uses and who actually controls the data. And the guidelines were perfectly aligned with OECD's goal, promoting information exchange, preventing unnecessary barriers to trade. Member states were encouraged to think about the effects of processing data domestically and then sending it to other countries. The aim was to ensure data flows smoothly and securely.
Okay.
Countries could generally share data among themselves, unless maybe a receiving country didn't follow the guidelines, or if re-exporting it would violate laws. They also allowed for limiting certain types of sensitive data if the receiving country didn't offer, comparable protection.
So some conditionality.
Yes, but the overarching caution, the main message, was not to create laws that unnecessarily hindered the flow of personal data in the name of privacy. That became a key focus of later legally binding instruments, how to protect and allow flow.
Okay, that makes sense. Next, Convention 108, adopted by the Council of Europe in 1981. You mentioned it was the first legally binding international instrument in data protection. How significant was that distinction, being binding versus guidelines?
Oh, there's a monumental distinction. Unlike the non-binding OECD guidelines, Convention 108 requires its signatories, the countries that sign up, to actually adjust their domestic laws to follow its principles.
They have to do it.
They have to do it. They couldn't just say, oh, we'll try. Yeah. They had to implement it. It was also intentionally open to non-European countries, hence not being called the European Convention. Argentina, for instance, became the 54th signatory way later in 2019. Shows its global reach.
Oh, okay.
It essentially consolidated those earlier Council of Europe resolutions from 73 and 74, and its preamble explicitly lays out its goal: increase unity among members, enhance protections for everyone's rights, especially privacy, precisely because personal data was increasingly being transferred across borders for automatic processing. It was truly the first binding instrument to set concrete standards for data protection, while again balancing those safeguards against the need to maintain the free flow of personal data for international trade. That same balancing act.
So, with that binding power, what were the core principles laid out in Convention 108, particularly in Chapter 2? How did they build on what the OECD guidelines suggested, but now with legal force?
The principles were quite similar to OECD and the earlier resolutions, as you'd expect, but now they had legal teeth. Data undergoing automatic processing had to be obtained and processed fairly and lawfully. Adequate, relevant, and not exhaustive. Accurate and kept up to date, preserved no longer than required for the purpose, and protected by appropriate security measures against destruction, loss, unauthorized access, etc.
Sounds familiar, the binding.
Exactly. And crucially, it formally introduced the concept of special categories of data, things like racial origin, political opinions, religious beliefs, health info, sexual life, criminal convictions. These required specific, stronger domestic safeguards because of their heightened sensitivity.
Right. Sensitive data needs more protection.
Precisely. And individuals were granted concrete rights. the right to communication about their data, and importantly, the right to rectify or erase incorrect data. And again, like the ECHR, exceptions were allowed, but only when they were necessary measures in a democratic society, reflecting that principle of proportionality we keep coming back to.
Okay. And how did Convention 108 handle trans-border data flows in Chapter 3? How did it enable that smooth data movement while ensuring protection now that it was binding?
Well, Article 12 of Convention 108 basically said that signatory countries cannot ban or require special permissions for data transfers between each other.
Ah, because they're all signed up to the same rule.
Exactly. Because they've all agreed to follow the convention's rules, there's a baseline level of protection assumed. So data should flow freely between them. Now, specific, tightly controlled exceptions or derogations were allowed in certain cases. For instance, if the sending country had special laws for certain data types and the receiving country didn't offer the same level of protection, or maybe when sending data to a country that hadn't signed Convention 108 at all.
Okay, limits for non-signatories.
Yes. And later, the 2001 Additional Protocol expanded on this. It introduced the concept of ensuring adequate protection for data sent to non-member states. With exceptions possible for individual or public interest, or maybe using approved contractual clauses, this adequacy concept becomes really important down the line, especially with GDPR.
Right, I've heard that term adequacy. And finally, Convention 108 also focused on mutual assistance in Chapter 4. What did that involve, and why was it so important for an international treaty like this?
Yeah, that mutual assistance part was vital for making it actually work in practice for enforcement. Parties, the signatory countries, were required to designate a supervisory authority, like a data protection agency, to oversee compliance within their country.
Okay, a watchdog.
A watchdog, exactly. And these authorities had to liaise with other countries' authorities for consultation and assistance. They also had to help individuals exercise their rights, even across borders. This was reinforced by that additional protocol, too. Convention 108 really is unique as the only binding international legal instrument in this field with a potential worldwide scope open to any country. And that mutual assistance piece truly underpinned its practical effectiveness.
So, by the early 80s, we had these crucial OECD guidelines and a truly binding international convention, Convention 108. Sounds like things are pretty well set, right? Progress. But the sources highlight this continuing need for a harmonized European approach.
Yeah.
What went wrong? Why wasn't that enough? Why the push for more?
It's an interesting paradox, isn't it? While Convention 108 and the OECD guidelines aimed for a unified method, member states still ended up implementing the principles in various ways, different interpretations, different enforcement levels.
Ah, the implementation gap.
Exactly. This diversity, this patchwork, it hindered free trade, which was a core principle of the EEC under the Treaty of Rome, aiming for that single market. It also meant that even with the convention in place, people's basic rights could still be affected differently depending on which country their data was in or flowing through. Inconsistencies remained.
And this led then to the Data Protection Directive in 1995. How is this different from previous efforts? What did it aim to achieve by being an EU directive specifically?
Right, so directives are a specific type of EU law. Member states must achieve a specific result, but they allow each country to decide how to implement it into their national law. So some flexibility remains.
Okay, goal set, but method varies.
Precisely. This directive was proposed exactly to address those persistent, inconsistent national laws that were hindering the internal market, the free movement of goods, services, and data. It was based squarely on Convention 108 principles and aimed to provide a similar high level of protection. It covered both automated and non-automated personal data in public and private sectors, and it specifically aimed to reinforce the ECHR's Articles 8 and 10 on privacy and freedom of expression.
So, trying again for consistency, did it work this time?
Well, partially. It was a big step forward, but differences in implementation still persisted. Reports as late as 2003 highlighted this. This continued fragmentation created significant burdens for businesses, especially those operating across borders or sending data outside the EU. Think about varied notification requirements for data protection authorities in each country. It got complicated. The dream of seamless harmonization wasn't fully realized yet.
Okay. Before we get to the big one, the GDPR, two other critical developments truly paved the way, strengthening the foundations. First, the Charter of Fundamental Rights. What did this add, especially regarding data protection?
The Charter of Fundamental Rights, yes. Signed in 2000, it became legally binding with the Treaty of Lisbon in December 2009. Big moment. It strengthened fundamental rights across the entire EU, building on existing treaties, case law from the courts. But importantly for our story, it specifically emphasized personal data protection in a way that hadn't been quite so explicit at the EU level before.
So data protection gets its own spotlight.
It really does. Article 7 covers privacy, much like ECHR Article 8. But then Article 8 is specifically titled Protection of Personal Data.
Ah, okay.
And it details the core values: fair processing, specified purposes, consent or legitimate basis, the right to access and rectify data, and crucially, the need for an independent supervisory authority to oversee it all. And, like with human rights generally, any limitations must always align with necessity and proportionality. It really elevates data protection.
And then the Treaty of Lisbon itself, in effect from 2009. How did it further solidify data protection's place in the EU legal framework? Did it make it even more central?
Absolutely. Lisbon's main goal was to enhance and streamline the EU's core structures, creating a much more unified legal framework for all EU activities. And crucially, the Treaty on the Functioning of the European Union, or TFE, as amended by Lisbon, explicitly states in Article 16, paragraph 1, that everyone has the right to the protection of personal data concerning them.
Right there in the main treaty.
Right there. And Article 16, paragraph 2, then mandates that the European Parliament and Council will lay down the rules for safeguarding personal data processed by EU institutions and by member states when carrying out EU law activities. And it again mandates independent authorities overseeing compliance. This means all EU institutions have to protect data, cementing it as a fundamental EU right and obligation, not just something left to individual member states.
Okay, the stage is well and truly set. All these developments then brought us to the big one, the General Data Protection Regulation, or GDPR. After all these years of directives, conventions, why was a regulation needed? What made this different and, well, so impactful?
The GDPR, yeah. Published in 2016, enforceable from May 25, 2018. It was a direct, decisive response to everything we've just discussed. The 1995 directive, as we noted, hadn't delivered the consistency needed. Rapid technological advancements, the internet, social media, big data, and globalization had simply outpaced it. The old directive just couldn't keep up.
So time for a major overhaul.
Exactly. And the key difference here is monumental. Unlike a directive, a regulation applies directly to all member states without needing national implementation laws. It's the law across the EU.
Direct application, that's the game changer.
That's the game changer. It aims for far greater consistency and uniformity across the entire EU. Its goal was ambitious: build trust in the digital economy by finally addressing fragmented data protection rules, legal uncertainties for businesses, and the new online risks individuals faced. Now, it's worth noting, it still allows some flexibility for specific national rules in certain areas like employee data, scientific research, processing sensitive data, legal obligations, so some minor divergence might still exist, but the core principles are universally applied.
What were the key shifts, the big changes the GDPR ushered in that we as listeners should really know about? What makes it different in practice?
The GDPR brought in some really profound changes that affect businesses and individuals pretty much worldwide, given its reach. It introduced much stronger rights for individuals, especially concerning their data in the online environment. Think right to erasure, data portability, giving them more control.
More power to the individual.
Definitely. It mandated data protection by design and by default. This means you have to think about data protection right from the very start, when you're developing new technologies or services, not just bolted on as an afterthought.
Build it in from the start.
Build it in. There's also the crucial concept of accountability. Organizations aren't just told to comply. They must be able to demonstrate their compliance, show their work, essentially. It gave significantly increased powers to those supervisory authorities we mentioned, including hefty fines for non-compliance.
Right. The fines got attention.
They certainly did. And it introduced the one-stop shop concept, meaning businesses often deal primarily with one lead supervisory authority, and individuals can more easily seek redress, even across borders.
Okay, simplifying things a bit too. And around the same time, Convention 108 also got a major upgrade, becoming Convention 108 Plus. How did it align with the GDPR? Was this reinforcing that unified approach?
Absolutely. The modernized Convention 108 Plus, signed in October 2018, was actually 7 years in the making. It was explicitly designed to increase data protection standards globally while ensuring compatibility with new regulatory frameworks like GDPR. They wanted them to work together.
Makes sense.
So, not surprisingly, it adopted many GDPR principles and mechanisms. This includes central definitions like processor, the need for a specific legal basis for processing data, the inclusion of new special categories like genetic or biometric data, ethnic origin, trade union membership. Things that reflect modern concerns.
Updating for the times.
Exactly. Enhanced security and breach notification rules, transparency requirements, accountability, and even the idea of examining the data processing impact on rights before you start, similar to GDPR's impact assessments. It even aligns explicitly with GDPR Recital 108. This means the European Commission considers whether a non-EU country has adopted Convention 108 when deciding if that country provides adequate protection for data flows. So adopting 108 plus helps countries get that adequacy status.
So it boosts its global relevance even more.
Precisely. It helps make it a truly global standard, working hand in hand with GDPR.
Beyond these big framework laws, GDPR, Convention 108 plus, what are some of the other specific pieces of legislation that came out of this evolving landscape? You said it's multi-layered.
It absolutely is. Two other notable ones worth mentioning are the Law Enforcement Directive, or LED, and the E-Privacy Directive. The LED, introduced alongside GDPR in May 2016, specifically aims to harmonize rules for processing personal data by police and judicial authorities across EU member states when dealing with criminal matters.
Okay, a separate track for law enforcement.
Yes, it recognizes that law enforcement agencies have distinct data needs and operate under different constraints. So it provides a separate but harmonized framework that still ensures fundamental rights are upheld, even in sensitive security contexts. It's that balancing act again.
Always the balance. And the E-Privacy Directive.
Right. The E-Privacy Directive focuses more narrowly on the privacy of electronic communications themselves. Think your phone calls, faxes, texts, video messages, emails, internet messaging, confidentiality of communications.
So the content and metadata of messages.
Exactly. It doesn't generally cover, say, widely available web content. It sets specific rules for things like cookies, consent for tracking, confidentiality. This directive understands that these intimate forms of communication demand specific protections beyond just general data handling rules found in GDPR.
And how does it relate to GDPR?
Well, GDPR clarifies it doesn't add extra obligations where e-privacy already applies. However, the e-privacy directive itself is currently undergoing a long and complex update process to better align it with the GDPR framework. Shows the ongoing complexity of regulating privacy in electronic communications.
Yeah, that sounds tricky. Okay, finally, let's talk about Brexit. How did the UK leaving the European Union affect this carefully constructed data protection framework that we've just spent all this time dissecting? Did it throw a wrench in the works?
Well, it certainly created a new situation. Before Brexit, the GDPR was directly applicable law in the UK, just like any other EU member state. After Brexit, the UK essentially took the GDPR text and incorporated it into its own national law. They created what's known as the UK GDPR, which works alongside their existing Data Protection Act 2018.
So basically copied and pasted.
Largely, yes, at first. It mainly involved replacing EU or member state references with UK equivalents and designating the UK's Information Commissioner's Office, the ICO, as the independent supervisory authority. So the UK's the catch is potential divergence. While the UK framework started almost identical, the UK can now change its laws independently. However, it has to constantly consider the risk of disrupting the free flow of data with the EU, which is vital for trade. The EU expects the UK to continue following international rules, respecting human rights standards, accepting ECTHR authority. If the UK diverges too much, it could negatively impact those adequacy decisions we mentioned earlier.
Right, adequacy. What exactly are these decisions in this post-Brexit context, and how do they play out for the UK? It sounds like a big hurdle to clear.
It really was a crucial hurdle because the UK officially became a third country, meaning non-EU. Non-EA data flows from the EU to the UK became restricted under GDPR rules.
Data couldn't flow freely anymore.
Not automatically.
Right.
Transfers are only allowed if the third country, in this case the UK, is deemed to provide an adequate level of protection under GDPR Chapter 5. The European Commission has to make a formal decision.
So did the UK get one?
Yes, eventually. On June 28, 2021, the European Commission adopted two adequacy decisions for the UK, one under the GDPR for general data and one under the Law Enforcement Directive for police and judicial data.
Phew, okay. So data can flow.
Yes. This effectively means the free flow of personal data from the EU and EEA to the UK can continue, which was a huge relief for businesses on both sides. These decisions were based on the Commission assessing things like the UK maintaining the rule of law, respecting human rights, providing effective rights for data subjects and ways to seek redress, having an independent ICO, and adhering to international commitments like Convention 108.
But is it permanent?
Good question. Here's a key detail. Unlike most other adequacy decisions the EU has granted, the UK's decisions have a sunset clause. They automatically expire after 4 years, so in mid-2025.
So they need renewal.
They will be reviewed again by the European Commission before then. The possibility of renewal exists, but it depends on whether the UK continues to ensure an adequate level of data protection in the EU's eyes. It adds an element of ongoing scrutiny.
Interesting. And data flowing the other way, UK to EU.
That's generally less complicated. Data flowing from the UK to EU member states is permitted under the UK's own data protection framework for international transfers, as EU countries are obviously considered adequate by the UK.
Okay, that makes sense. So what does this all mean for us, for individuals, for businesses navigating this complex landscape? We've traced this remarkable evolution from, worries about early computers to this complex, interconnected global framework that directly impacts how our digital lives are managed.
It's truly been a journey, hasn't it? And it's fundamentally driven by this recognition, particularly strong in Europe, of privacy as a human right. It's this constant seeking to find that vital balance, a balance between individual control over personal information and the needs of society, the relentless pace of technological advancement, and the undeniable imperative for free trade and the free flow of information in a globalized world. From those early, non-binding guidelines through international treaties like 108 to directly applicable regulations like GDPR, the persistent effort has been to create a coherent system. A system that provides robust protection while still enabling innovation and global commerce.
This deep dive really shows us how deeply ingrained data protection is in the European legal and, maybe even more importantly, ethical fabric. It's not just about technical rules. It really is about fundamental freedoms and a deeply held societal value.
Absolutely. And this whole journey, this constant evolution, it raises a really important question for you, the listener, to think about moving forward. Given how rapidly technology continues to evolve, think about AI, quantum computing, maybe even brain-computer interfaces down the road. What do you imagine will be the next frontier in data protection law? What new challenges will emerge? What new balances will need to be struck in an increasingly, almost unimaginably connected world?